Welcome back, law students. Today we're diving into a crucial explainer on Brazilian industrial property law. We're going to break down the statutory differences between an invention patent, or PI, and a utility model, or MU. Understanding this, it's not just about acing your exams, it's absolutely crucial for knowing how to strategically protect your future clients' innovations.
Let me ask you something to get us in the right academic mindset. When you hear the word patent, do you immediately picture Thomas Edison's light bulb? Or maybe the very first personal computer? It's a totally common misconception, sometimes even pushed by legal scholars, that patents only exist to protect these massive, world-changing breakthroughs. But as we're going to see today, the law is way more nuanced, and it protects everyday, practical improvements just as fiercely.
Okay, let's dive into this. Here is our agenda for today's explainer. The patent concept, basic legal requirements, invention versus utility model, the inventive threshold, deadlines and validity, and legal protection implications. Let's jump in.
Section 1. The concept of a patent. State monopoly and territoriality.
Before we even think about arguing the nuances of utility models in court, we really have to understand the foundational philosophy of state-granted monopolies. Consider the Carta Patent, or letters patent, issued by the Brazilian National Institute of Industrial Property, the INPI. This isn't just some ceremonial certificate. It is the tangible, official title of temporary property granted by the state to the inventor. It is quite literally your client's sword and shield in a marketplace that's constrained by national borders.
But here's the catch. This state-granted monopoly is absolutely not a free gift. It represents a grand legal bargain. The state grants exclusive economic rights to the inventor for a very specific period of time. In exchange, the inventor has to fully reveal the technical secrets of their creation to the general public. It's a classic trade-off. You get exclusivity, but you must provide disclosure, which ultimately drives the overall technological progress of society.
Moving on to Section 2, Basic Legal Requirements. Deconstructing Article 8 of the LPI.
All right, getting into the black-letter law here. Under Article 8, whether it's an invention or a utility model, it has to hit 3 strict legal requirements to actually be patentable. First up is novelty. It has to be completely different from anything previously disclosed in the market or the state of the art. Second is the inventive step, or inventive act. Basically, it cannot be blatantly obvious to an expert working in that specific field. And third is industrial application. Mere ideas, not patentable. The creation must have a tangible purpose and real industrial functionality.
Which brings us to Section 3, Invention versus Utility Model, the direct confrontation of concepts.
So, how exactly does the law distinguish a major, disruptive breakthrough from a really good practical improvement? Let's draw a hard line here. An invention patent, a PI, provides a completely new technical solution to a specific problem. Think along the lines of a brand new chemical compound or a revolutionary manufacturing process. A utility model, an MU, on the other hand, strictly requires an object of practical use. Crucially, it has to have a new shape or physical arrangement that results in a functional improvement in how it's used or manufactured. Think of things like a highly efficient modular drawer organizer or a left-handed pair of scissors. It's all about practical, physical utility.
So the really crucial point here is understanding exactly what the utility model does not cover. As you know in law, a definition is often best understood by its exclusions. Because a utility model requires a macroscopic, palpable object of practical use, you absolutely cannot use it to protect chemical formulas, new synthetic materials, manufacturing processes, or embedded software. If a client walks into your office with any of those, you're looking strictly at an invention patent.
Section 4. The inventive step threshold. Inventive activity versus inventive act.
When we get into the weeds of Article 9 of the LPI, we really need to distinguish between these legal thresholds. There's a brilliant quote from the eminent Brazilian legal scholar Denis Borges Barbosa that I absolutely love. He notes, "The utility model is the worker's patent, especially those in the mechanical industry." That perfectly captures the essence of the MU. It's not meant for the multi-million-dollar R&D lab. It's designed to protect those clever, everyday, highly practical innovations coming right off the factory floor from engineers, artisans, and small inventors.
And legally speaking, this is framed as the inventive act. See, for an invention patent, you need inventive activity, which implies a massive, non-obvious leap. But for utility model, the law only requires an inventive act. It just has to be a new shape or disposition that isn't completely common or vulgar. Because this creative threshold is significantly lower, a utility model is, in practice, a whole lot easier to get granted by the NPI than a full invention patent.
Section 5, Deadlines and Legal Validity.
The chronology of protection under Article 40 of the LPI. Okay, so once you actually secure this protection for your client, how long does the clock run? Well, the magic number for an invention patent is 20 years. That is 2 solid decades of general legal validity and market monopoly, counting strictly from the date the application was filed.
Let's contrast that and see how the timeline builds for our other category. The general validity for a utility model is a bit shorter, exactly 15 years, and again, counting from the filing date. So you get that lower inventive threshold, but you do trade away 5 years of market exclusivity.
But hey, you're future lawyers, right? So you already know there's always an exception to the rule. And this one is huge. The INPI famously has a massive backlog of applications just waiting to be examined. To stop inventors from unfairly losing their monopoly time just because of bureaucratic delays, the sole paragraph of Article 40 steps in. It guarantees a minimum term of validity, no less than 10 years for a PI and 7 years for an MU. Note the absolutely critical shift here. This minimum guarantee is counted from the actual date of the grant, not the initial filing date.
Finally, Section 6, Legal Protection Implications, Theory versus Practice in Litigation. All right, we've read the statutory text, but let's translate this theory into real-world practice. Why would you ever advise a client to file for a utility model instead of an invention patent? Well, the main advantage is the ease of grant. It simply clears the INPI faster because of that lower inventive threshold. However, you've got to be super cautious in litigation. Judges tend to prefer a very strict literal interpretation for MUs. It is incredibly difficult to argue infringement by the doctrine of equivalence with an MU compared to a PI. Plus, if your client is looking at a global strategy, keep in mind that many foreign jurisdictions don't even recognize utility models at all, making international filing a total headache.
So, I want to leave you with this final thought today. As you step out of the classroom and into your future legal careers, and a client drops an amazing new prototype right on your desk, how are you going to advise them? Will you fight for the broad 20-year protection of an invention patent? Or will you strategically choose the quick, highly accessible shield of a utility model? The choice, counsel, will be entirely yours. Thanks for joining this explainer and keep studying those nuances.